We are at the moment talking about dissolution of partnership, and we were talking about the cases, you see, of dissolution which takes place on the happening of certain contingencies. Section 42 says dissolution on the happening of certain contingencies. And contingencies, you know, in law of tort, we have talked about it. If you recall, we have talked about contingent contract. Contingency is an event, is an uncertain future event. So the contingencies which causes the dissolution of firm is number one was expiry of the term of particular partnership. We talked about it. Completion of adventure or undertaking when the partnership is has been constituted for a particular adventure or undertaking. On the completion of such adventure or undertaking, the partnership or firm would be dissolved automatically. Section 42C talks about third kind of event which causes the dissolution of the firm, and that is death of the partners. Just suppose that there are 10 partners in a business and one of them passes away. One of them passes away, he dies. So the firm would stand dissolved. It will automatically will get dissolved. Uh, if one of them has died, you see, the firm would be dissolved, but it never means that the firm cannot continue doing its business. It can be reconstituted. I mean, the remaining 10, 9, they can decide to continue the business, and most probably they will be continuing. So far as the contribution of the deceased partner in the firm's capital, what would be done with that? There can be two possibilities. Possibility number one is, you see, that they naturally he was their partner, their friend said they would like to benefit the family. So how can they benefit the family of the deceased partner? They can introduce his children, one of his children, provided they have attained the age of majority, they are above 18 years. If unfortunately none of the children of the deceased partner has attained the age of majority, then they can invite the wife to come and step into the shoes of her deceased husband, so that she or the poor family can get benefit of the, the profit which they will be earning out of the business of the partnership. Just suppose if the lady does not agree, if the widow does not agree, she doesn't want to be a partner with the man, then I mean, is there any other way? Yes, there is another way about which we talked in the last lesson. They can admit the minor children, either son or daughter, you see, for the benefit of the partnership. He would not be partner, as we discussed in detail last time. He would not be a full-fledged partner, but he will be getting benefit of the profit which the firm would earn. You see, these are the cases. But in case where the family is not willing to agree that one of their minor children be admitted for the benefit of the partnership, and the poor widow is also not, if they don't need, naturally the firm would be dissolved on the whenever you see it is notified that when it is known by the partners that one of their co-partner has passed away, the firm would be dissolved. The business in that case where neither the lady agrees to become a partner, nor you see she agrees to one of his minor children be admitted for the benefit, she can take out her deceased husband's share from the capital of the partnership. The business would be wound up, the accounts would be settled down, and the remaining partner can carry on business. They will reconstitute the firm. And for again and again, I'm telling you that neither for constitution of a partnership nor for reconstitution of a partnership, you see, a contract in writing is needed. Verbally, they can agree that this is the share of your deceased husband in the capital as well as in the assets. Take it and let us carry on the business with them. The next case in which a firm is, stand dissolved is the insolvency of a partner. When a partner has been adjudicated as an insolvent, you see, neither his son can be admitted. Oh, no, no, no. Even in the case of insolvency, but how his son would be? No, his son cannot be admitted to get benefit out of the business of the firm because that insolvency, whenever a person is adjudicated as an insolvent by a court, all his properties, all his assets are taken by the court and given in the charge of. So his son, his share in the firm business has to be submitted, has to be paid to the court, not to his widow, not to his family. That's why you see a minor son of an insolvent person cannot be admitted to take benefit of the partnership business. So the firm would be dissolved. It would stand dissolved in the case when even a single person is adjudicated by a court of law as insolvent. I hope you are understanding this. The next mode, the next mode, or the next uh, next way in which a firm is dissolved is mentioned in section 43. Section 43 talks about dissolution of partnership at will, and I don't need to tell you that partnership as at will is that partnership for which no time for its duration, for its continuance is fixed by the partners. So it's open, and any single partner can dissolve the firm. And how can he dissolve the firm? And what does dissolution here mean? A single partner, you see, can let the rest of the partners that I don't want to continue with you people, and I don't want to be a partner in your firm. So he can take out his share in the assets, including the capital of the partnership. But it never means that the remaining partners cannot continue the business of the firm. Yes, they can continue. And again, I'll tell you that they will dissolve. The firm would be dissolved whenever one of the partners decides to get out of the partnership business, and the remaining, they can reconstitute, and they can start by making a new contract in which the his name would not be included. The next mode of dissolution is dissolution by court. There are certain circumstances in which the court dissolves the firm, and this is section 44. There are, three circumstances in which a court can dissolve the firm. This is section 44. Okay. Uh, Section 44 is talking about dissolution of firm or partnership by court. There are 1, 2, 3, 4, A, B, C, D, A from G, A, B, C, D, E, F, G. There are seven circumstances mentioned in section 44, you see, which says that the firm would be dissolved by the court of law. But here, one question has to be considered, that section 44 talks about the circumstances in which a court will order the dissolution. Question here arises that whether the court would be invoked, the authority of the court would be invoked by someone, or the court would take the matter suo motu on its own. No, court court cannot take suo motu action for dissolution of a firm. Naturally, one of the partners will take the matter to a court of law. Then court of law will look into the matter, and if the court reaches to the conclusion that the firm has to be dissolved. And the next question for your consideration is that is it essential, is it mandatory for the partners to get the court dissolved, get the partnership dissolved by the court of law? No, they can do it at home. They can do it, without going to the court. But if one of the partners take the matter to a court of law, then the court can, if it is convinced that the situation demands that the partnership will be dissolved, only then the court can decide it. The first case in which the court, if applied, on the application of one of the partners, would order the dissolution of the partnership is mentioned in section 44, clause A. When a partner has become of unsound mind. Look, 10 people, they are running a business very successfully. Suddenly, God forbid, something happened to one of the partners, and he mentally, come across a mental disease that he cannot work as a partner. So is it essential? Just here, you need to use your legal wisdom after going through the language of the section. You see, at the suit, section says, at the suit of a partner, the court may. It's not saying that the court shall. I mean, it's not mandatory for the court. The court may or may not dissolve a firm. And naturally, if it is proved that one of the partners, has become mad and he cannot work as partner, while the rest of just 10 people are running a business, one of them is mad, and rest of the partners, they do not want to dissolve the firm, and one of them, he says that the firm must be dissolved and properly, the accounts must be properly dissolved, and then it should be decided whether the remaining partners are going to continue the business or not. He can file a suit, he can file an application to a court of law under section 44, clause A. You see, if, and the court, if court will naturally look into the matter in detail and will call the rest of the partners as defendant. In this case, the applying partner, the partner who applies to the court of law that one of them has gone mad, and he asks the court to order the rest of the partners to dissolve the firm, and they are not willing. He will be a plaintiff, and his co-partners would be defendants, and the case would be heard properly like a civil suit. And if the court does not find, if it is not proved that one of them has gone mad, naturally court would, the case would be dismissed. Okay, the case would be dismissed, and that the partner who wants to get it dissolved would fail in his plea. But if it is proved that yes, there is one of the partners has gone mad, and the partners or the firm is the partners don't want to get the firm dissolved, they can continue, you see. And this is not the only way. The one who is who wants to get the firm dissolved by the court of law, this is not the one way. He can dissolve it by serving a single notice to others. If they are not willing, and if they are insisting that although their friend, the co-partner, is mad, but let us continue with his share in the partnership, he can serve. He can serve, a notice. on the remaining partner to dissolve it if it is partnership at will. Yes, if it is partnership, particular partnership, then there will be, he cannot get it dissolved by serving a notice. Naturally, he will have no way to file an application in a court of law. Okay, so uh, second circumstance or the second case in which a court, uh,
Excuse me, sir.
yes, Wasim
Sir,
Raza.
who can sue? Who can sue the sue? Who can sue? Mad or other partners?
No, 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 no. Mad. You see, he cannot sue. One of the partners, naturally, he will sue the firm for dissolution. Okay, good question. The second
Okay, sir.
case,
Thank you.
the second case is where a partner becomes permanently incapable to perform duties. Okay, you see, if you remember the definition of partnership, there can be partners who say that they will invest in the partnership business, but they would not take active part in the business. So that's good, that's possible. But if a partner who is not a dormant or sleeping partner, he, you see, becomes incapable of performing his duties. Like if he has got a green card of Canada, he is migrating, okay, or if he is sick, paralyzed, he cannot attend his duties which are assigned by the firm to him. In that case too, you see, when a partner other than the partner suing has become, so one of the partners can take the matter to a court of law and saying that, you see, one of them has gone to Canada, he has gone with the intention of getting immigration, so the firm should be dissolved. First of all, he should talk to his fellows, his the co-partners, that look, let us you see, dissolve it. If they are not insist, if they are insisting, no, he's our friend, he's our brother, let him stay, let him get the immigration of Canada. You see, or if even if he is paralyzed, even if there is no hope that in future he will come and he will start his normal duties at the firm, if they insist, then he can, even in that case, you see, the partner who wants the firm to be dissolved need not to go to the court. He can serve a notice provided the partnership as at will. But you see, he would need to go to a court of law when the partnership is not partnership at will. It is a particular partnership for which a time period has been fixed. So he will have no way to apply to the court of law, you see, informing the court that one of them is permanently incapable of performing his duties and the partners are not dissolving the firm. Please help me to get the firm dissolved. Okay. And the next is misconduct by the partners. If one of the partners is misconducting in any way, he is involved in misbehavior, in embezzlement of fund or whatever, you see, you can think of misconducting. In that case too, you see, any one of the partners can take the matter to a court of law. Again, I'll tell you why the partner who is applying to the court for getting the partnership dissolved, why he is going to the court, because he has no way. And all these cases relate to the particular partnership which cannot be dissolved by a single partner unless the time period which is fixed for the business is expired. So naturally he'll have no way. If it is partnership at will, you as a lawyer or you as a business executive can advise him that, look, you don't need to waste your money by going to the court and filing an application for dissolution of firm. It's partnership at will. You just serve a notice upon them, and if even after serving a notice upon them for resolution of partnership, they are not willing, then you can go to the court. So if a partner is involved in misconduct of the business or any type of misconduct, you see, any of the partners you see, can take the matter to a court of law, and if the court is convinced, the court can order that the firm shall be dissolved. This is section 44C. Section 44D talks about partners breaches the contract. You see, breaches the contract. I mean, partnership is a result of a contract, and every partner, even if they are 10 in number, every single partner is bound to perform his part of contractual liability, contractual duty, if one of the partners is found in any way, you see, breaching the contract. If just suppose that in one of the clauses of the Partnership Act, partnership contract, it was agreed that just suppose that the firm has a business of importing cars from Japan and selling them in Pakistan. And it has already been expressly mentioned in the contract, expressly mentioned in the contract. Don't think that contract must be in writing. Expressly, they verbally agreed, either they verbally agreed that they will never sell a single car on credit, they will sell it on cash. It is well settled, either verbally or in writing if the contract is in writing, and most probably the contract would be in writing, although this is not a legal requirement. But I told you that such a big deals, people are, you see, very vigilant, and they get their deals written. So if it has expressly been mentioned in the Partnership Act that cars would be sold only and only on cash, not on credit. And you also know that all the 10 partners, they have an implied authority, you see, of disposal of business. Just suppose that one of the partners, he sells a car to one of his friends or relatives on credit, on installment. This is breach of contract. In that case, you see, if the matter is taken to a court of law by other or any one of the remaining partners, the court, and if it is proved that he has breached the contract, he has gone against one of the provisions of the partnership contract, the court will order that the partnership shall be dissolved. In the same way, you see, the next case in which the court will order dissolution of a firm is the case of Section 44, Clause E, when a partner transfers his interest to another, either to another partner or to a stranger. So interest of a partner cannot be transferred unless 100% of the partners are agreed. If suppose one has said that, oh, look, I'm going to start a new business, or I'm going to migrate to Canada. So my brother or my sister or my cousin or my friend, please accept him as a partner. This is up to the partners. You see, if all of them, they have agreed, he can be admitted as a partner, the partnership would be reconstituted. But if one of the partners is not willing to this arrangement, he can file a suit against the firm, I mean to say against the rest of the partners. And if the court, you see, after hearing the case, you see, comes to know that a partner has transferred his interest in the partnership business to another partner or to a stranger, to an outsider, the court will order that the firm should be dissolved. But there is no difficulty. Just suppose that I'm one of the partners and I am asking the partners, my co-partners, to relieve me because I'm no more interested in the business, and to admit one of my cousins or friends as partner. If they are willing, well and good. If 100% of them are willing, very good. If not, then you see, then I have no way. You see, I can be sued. If they are willing, well and good. If they are not willing, I can't insist. And in that case, if they are not willing, and if even one of them is not willing to admit my cousin or friend as their partners, he can file a suit against the court under section against the firm under section 44E, when a partner transfers his interest, you see, the business of the firm, if the business, just suppose we are 10 people running a business, for the last 6 months, for the last 1 year, you see, uh, the business is at loss. Continuously, we are coming across the loss. So naturally, you see, everyone would be asking for breaking down the relation of partnership. Okay. Again, I'll tell you that if the period is fixed, then a single partner who is not willing to continue will have no right to dissolve it. If it is partnership at will, no need to go to a court of law. If we are 10 people and business is at loss for the 6 months, uh, and I want to get it dissolved. It's very easy if it is partnership at will, no time is fixed for the partnership. I'll say, bye bye, give me my money, and I want to go home, I want to invest somewhere else. But if it is particular partnership, when you see the time for partnership is fixed, then you see, there will be no way for me to file a suit against the firm for dissolution under section 44F. I think it's clear when the business is at loss and a single partner is not willing to continue, either one or two or few of them are not willing to continue, and the rest they want to continue, you see, and unfortunately, the partnership is at will for a fixed period. You see, that unwilling partner or unwilling partners, they can go and file an application, a suit against the firm in a court of law. And if the court of law, after hearing the suit in detail and after arguments and after evidence, you see, uh, it will order that the firm shall be dissolved. Last clause of section 44 is normally called Omnibus Clause. Omnibus Clause. Besides these circumstances, for any other ground, for any other reasonable ground, you see, under section 44G, a firm can be dissolved by the court on any other ground, which in the opinion of the court renders is it just and equitable that the firm should be dissolved. There is neither insolvency nor death nor you see businesses at loss, but there is some other reason which is not mentioned in section 44. There can be a reason for which a partner, you see, or few partners, they they want the firm to be dissolved. So they must have some reason for that. If they have some reason, they can go to the file. They can go to file a suit against the firm for dissolution under section 44. So here we end the chapter of dissolution of firm, and you see, the next part of today's lesson is rights and liabilities of partners uh, after dissolution. But we will take, because the time is to end, I'll come back after 5 minutes with the new session, and then we will we will talk about, you see, the rights and liabilities of partners after dissolution. Okay, Khuda Hafiz.